Stop talking.
Yes, ma'am.
All right, Mr. Lackley's case, Mr. Young?
Yes, Your Honor. All right. So yes, Mr. Lackley is also going to work this out with the property. What we've agreed to in the meantime is a writ of possession to issue November 28th at 11:59 p.m. with a judgment calculated through that date of $3,813.73.
Thank you. Mr. Lackley, can you unmute for me, please?
Yes.
All right, and raise your right hand.
Yes.
Do you swear or affirm the testimony you're about to give in this matter will be true and correct under penalty of perjury?
Yes.
Thank you. All right, sir, did you come to a consent agreement with the landlord's attorney?
Yes. I have just one question to ask before. You clicked over pretty fast. I just thought about it. It's on the 28th. Is there any way that I can have that on the 1st? Because he did express leniency in a few days, for a few more days we needed to.
That is not a question for me.
For dispositionary warrant, instead of the 28th, would need the 1st because due to a government shutdown, some payments have reoccurred, but it won't be on track, according to the arrangement that was here. So it just needs that to go on with the other money that I already have, that I haven't been able to pay due to the portal.
Right. So what I'll say is, just what I said before. But if we do the 28th at 11:59 p.m., that is a Friday night.
How much on the 20th is going to be wanted? Because she's not cooperative like that. So you're saying 8, but the paper says $2,198. So do I pay that first?
Okay. No. Okay. So I'll reiterate again. You need to speak to the property to find out the exact number of what is owed and what they're willing to accept. This is just the judgment amount that would be through the 28th.
Okay.
This is not the number to pay to stay. That you have to talk to them about that, and it's 100% up to the property as to whether they accept any payment, really. So you want to talk to Lynn at the property about that.
Okay. If Lynn is not corresponding, just for on the record, what's you all's protocol for that? Could I call you and give you or could I notify you all through the courts or through the federal government or something like that for a few days to move out of the property, just in case she doesn't want that, because it does say a different amount. I'm not trying to be irritable about it. I just have to make sure, because once you hang up, then I have to just deal with the person if she's gonna be here at all.
Right. She's the person you'd have to deal with. She is 100% in charge of whether money's accepted or not. She does not have to legally. It is up to the property at this point.
Okay.
Yeah.
The property manager or the property? The
property manager is who you'd want to speak with.
All right. Okay.
All right.
All right. Are you all finished?
I believe so, Your Honor. Thank you. Sorry for the interruption in court.
All right, Mr. Lackley, did you come to a consent agreement with the landlord's attorney?
Yes.
Did you agree they would be entitled to a writ of possession on November 28th, 2025 at 11:59 p.m. and that there would be a judgment against you in the amount of $3,813.73?
Prorated, right?
That's the judgment amount that was given to me. Is that what you agreed to?
I say that when the paper says something totally different.
I think that you all need to go back into the breakout room. This is too much.
Yeah. I need to talk to him a little bit more. You're putting more onto it.
Yes, that's fine.
It doesn't sound right. Like I've done.
Everybody go in the breakout room, please.
Yeah, it doesn't sound right. I've been in prison and all that, and it don't sound right for me. It's just for me to just agree on the 28th to a higher amount than what's on the paper. It sounds like a fuck off to me. You know what I mean?
Excuse me, sir.
Oh, I'm sorry.
We do not talk like that in court.
Oh, I'm sorry.
That is contemptuous behavior, Mr. Lackley.
Oh, I'm sorry.
You do not stop talking.
Yes, ma'am. I need a representative. I didn't take my medicine. I'm sorry.
Stop talking. Go into the breakout room.
Okay.
Now. Not another word until you go into the breakout room.
All right, Your Honor, we are back. And everything is still the same.
Okay.
Mr. Lackley, is that what you consented to, a writ on the November 28th and a judgment in the amount of $3,813.73?
Yes, ma'am. I just didn't understand.
We'll send you a copy of your order once it's been filed in the clerk's office. Thank you. You are excused from court. And Mr. Young, you are as well.
Thank you, Your Honor. Have a good day.
And I will now call at this time case number GW 2025 CR 180, State of Kansas versus William Robert Shaw Jr. Please announce appearances.
May it please the court, the state appears by Judge-elect County Attorney.
William McClendon for the defendant, William Shaw. And is that you, Mr. Shaw, at the courthouse?
Yeah.
Okay. Judge, I have not had any contact with my client prior to
Phone's
today.
off. My phone is off. I apologize.
Okay. Can you take down my number and give me a call when you get a chance, and we can try to set up?
I do have your number because I actually lost my court papers and had to come up here and get them, or get my court date, and they gave me your number. I just haven't had a phone to call you on.
Judge,
Mr.
perhaps we can set this for the same date and let Mr. McClendon and Mr. Shaw have a breakout room.
We could do that, or if Mr. McClendon's in the office and wants him over there, or I don't want to put you on the spot, Mr. McClendon, you may have other obligations.
Judge, I think if we could just set this for the 13th, and then if I could get a breakout room after this, and we'll review it then.
All right, so I will continue this at Mr. Shaw's request to January 13th at 3:30. And let me look at your bond if you have one.
I was OR'd out, Your Honor.
All right. All right, I will continue on the $5,000 OR bond you posted September 30th, 2025. As I told the lady before you, if you don't come to court, you could end up owing the state $5,000 and a warrant for your arrest. So make sure you don't forget your court date, since it's not until January 13th. All right. If you look, we're going to put you in a breakout room.
Oh,
Go
I'm
ahead.
sorry.
Oh, you go ahead.
Is there any way I could ask you guys about the PFA or no contact order? About that?
Well, what is that?
Is there any way we could see about that maybe getting dropped so I could go home and see my kids?
Judge, this is a domestic battery. One of the kids is one of the victims, and the domestic battery, Kayla, is the victim.
All right. Yes, Mr. Shaw, I know you and Kayla that you're with are very dependent upon each other, but I see so many cases.
I have talked to Crosswinds, and I'm getting into anger management there.
Well, let's see how that goes first, because these kids, what are there, about 5 of them that keep seeing this happen over and over again, and that's going to affect potentially their outcome in life, and sooner or later you, Kayla, one of the kids might get hurt. So I'm going to have to do something different than what's been happening. You guys are going to have to stay apart for a while. I know that's tough. I know you have some medical issues, but once you get into Crosswinds anger management and you get some headway on that, maybe we can revisit this. But you and Kayla need to take a break for a while. I'm sorry, but that's just what it's going to have to be. So, but at the next hearing, January 13th, you can have a lot of anger management taken by then, and we'll see how things are going.
All right.
All right. We may
Am
go
I
with
gonna
this.
be? Can I at least get visitation with them still? Like you told me I could.
Do
Like
you
last
guys?
time, you told me I
Well, you
could
know-
see my 2 youngest ones, like with. Oh my goodness, I can't even remember.
He was supposed to be having supervised, but only with
Thank you. Yeah, thank you. I couldn't remember.
Well,
Just
what,
with my two youngest.
well, what stands out in my mind, Mr. Shaw, is that you years back convinced me to let you and Kayla have a family supervised Thanksgiving, and she ended up pregnant with one of those young kids, those youngest two. So I'm leery about giving you and Kayla supervised visits. So
She can't have kids, so.
she can't have any more. Well, she's got about
No,
what, 4?
she's been cut, tied, and burned.
Okay, and she's got about what, 4 or 5 now? 4?
No, she's got 4.
4. Yeah, the 4 little boys. Okay.
Mhm.
Although they're not as little as they used to be.
No,
Even that baby's not
Oh,
much of a baby anymore.
Brandon, he's not in school anymore. He works.
What did you drop out of high school?
Yeah, works for his
Okay.
papa.
I'm sorry to hear that he
Can't
dropped out
take the
of.
bullying. The bullying at this school, they don't take care of it. They do not take care of the bullying.
Well, we let him go to transfer to another school, and he didn't want to stay at that school. He wanted to come back to this school. So, we've done everything we can to help your family, and you just seem to go against it. So,
Yeah, but it doesn't help with Kayla not having a license and
no, I understand. There's lots of issues.
yeah.
All right. Well, I'm going to leave the bond as it is for now, but you get some
All right.
anger management, and we'll see what the anger management supervisor
All right.
person
Well,
says.
then I will probably head to Crosswinds right now. Talk to
All right,
them.
Mr. McClendon, what did we decide was going to be his next contact with you?
Judge, if I could just get a breakout with him right after,
Yeah,
immediately
All right.
after this, and then he's free to do that.
All right,
Okay.
Mr. Shaw, is there an officer there to help you with that breakout room? You basically just click on the screen and it'll put you in a private room with your attorney.
Okay.
What's it going to say, Missy? Invitation to breakout room? Or...
Yes.
All right, so look for that and click on it and you've got it.
Yeah, I see it.
Okay, thank you.